Hello and welcome. If you're watching this video, you're probably dealing with an important issue following your divorce, or maybe you're just planning ahead. Either way, I'm here to help guide you through understanding how to modify orders in Texas after a divorce has been finalized. I'm Lena Nguyen, and I'm a divorce lawyer here in Texas. In today's video, we'll be diving into the ins and outs of modifying custody, child support, spousal support, and other post-divorce orders in Texas. We'll also explore the legal standards for modifications and walk through the filing process. But before we dive in, please note that this video is for informational and educational purposes only and does not constitute legal advice. Every case is unique, and I recommend consulting with a family law attorney who can advise you based on the specifics of your situation. So let's get started. Modifying custody, support, or other orders. When a divorce is finalized in Texas, the court issues several orders that affect both parties and their children. These typically include orders on custody, child support, spousal support, and property division. However, life doesn't stop after a divorce, and over time, circumstances can change. When these circumstances do change, you may need to modify one or more of the court orders to better fit your new reality. In Texas, modifications of these orders are possible, but it's important to understand the types of orders that can be modified and under what conditions. Let's break it down. Custody orders. In Texas, the term custody is replaced by conservatorship when referring to parental rights and responsibilities. There are two types of conservatorship: joint conservatorship and sole conservatorship. Joint conservatorship is the most common form in Texas, where both parents share decision-making responsibilities regarding the child's upbringing. However, one parent is often named as the primary conservator, which means they make decisions regarding the child's primary residence. Sole conservatorship. In some cases, one parent is granted sole authority to make decisions about the child's care, typically when one parent is deemed unfit or unable to care for the child in a stable environment. Changes in circumstances that could trigger the need for a modification of conservatorship include a parent's relocation to a different city or state, a parent's health issues that make them unable to care for the child, a child's preference, especially if the child is older and expresses a desire to live with the other parent, abuse or neglect concerns that may require changes to the conservatorship or visitation schedule. For example, if a parent moves out of state for a new job, the child's best interests must be evaluated, and the court may decide to modify the primary residence order to ensure the child has a stable living arrangement that allows for ongoing contact with both parents. Child support. Child support is an obligation that one parent must pay to the other to help cover the child's living expenses. The amount of support in Texas is calculated based on a percentage of the paying parent's net income. The standard guideline amount is 20% of the paying parent's net income for one child, 25% for two children, and so on. However, changes in financial circumstances can warrant a modification of child support. These changes can include a significant change in the paying parent's income, such as a job loss, a significant pay cut, or a promotion that increases income substantially. A child's increased medical or educational needs, such as a development of a medical condition that requires ongoing treatment or special education services. The paying parent's remarriage or other financial changes that impact the ability to pay child support. For example, if a parent loses their job and is no longer able to pay the current amount of child support, they can file for a modification of the order. However, it's important to note that this change must be substantial and will need to be supported by evidence, such as tax returns, pay stubs, or medical bills. Spousal support. Spousal support or alimony is not automatically granted in Texas divorces. If awarded, it is typically only temporary and is intended to provide financial support for a spouse who is unable to support themselves immediately after a divorce. Texas law allows for spousal support in limited situations, such as the spouse requesting support has a disability that prevents them from earning a living, the spouse requesting support is the custodian of a child with special needs, making it difficult to work full-time, or the marriage lasted 10 years or more and the spouse requesting support is unable to meet their minimum reasonable needs. A spousal support modification may occur if the paying spouse's financial situation changes significantly, either improving or deteriorating, the receiving spouse's situation improves, such as if they get a new job or remarry. For instance, if the spouse receiving alimony remarries or starts earning a higher income, the paying spouse may petition to reduce or terminate the alimony payments. Property division orders. While property division is generally considered final after a divorce, there are exceptions. For example, fraud or concealment. If one spouse hid assets during the divorce process, the court may allow for the division to be revisited. Mistake or oversight. If a significant asset or debt was not addressed in the original property division, a modification may be possible, though these situations are rare. Legal standards for modifications. So how does the court decide whether to grant a modification of these orders? Well, in Texas, there are strict legal standards that must be met before any modification is granted. A substantial and material change in circumstances. Texas law requires that there be a substantial and material change in circumstances since the original order was made before a modification will be granted. This means that the request for modification cannot be based on minor or temporary changes, and the parent seeking the modification must show that the change is significant enough to justify the modification. For example, if a parent decides to move to a new city because of a job offer, this could qualify as a substantial change in circumstances. However, if the move is only for a temporary period, the court may decide that the change is not enough to modify the custody arrangement. Best interests of the child. When modifying custody and child support orders, the court's primary concern is the best interest of the child. The court will weigh several factors, including the emotional and physical needs of the child, the stability of each parent's home environment, the child's relationship with each parent, the child's wishes if they are old enough to express a preference. For example, if a parent's new living situation makes it difficult for them to provide a stable home for the child, the court may modify custody orders to give the other parent primary custody. Changed financial circumstances. For child support modifications, the paying parent must show that their financial circumstances have changed significantly. The change must be material and not something like a small fluctuation in salary or a minor job-related change. For instance, if a paying parent loses their job, this could be grounds for a modification of child support payments. Filing and navigating the modification process. Now that we've covered the types of modifications and the legal standards, let's talk about how to actually go about filing for a modification of your divorce orders in Texas. The petition for modification. The first step in requesting a modification is to file a petition for modification with the court that issued the original divorce orders. The petition must include the specific orders you want modified, such as custody, child support, or spousal support. The grounds for the modification, such as a substantial change in circumstances or a change in the child's needs. Supporting documentation to back up your claims, such as income statements, medical records, or other evidence. For example, if you're seeking to modify child support due to a job lost, you would include pay stubs, proof of unemployment, and a letter from your employer. Filing fees. There is typically a filing fee associated with submitting the petition ranging from $200 to $400 depending on your county. If you cannot afford this fee, you may be eligible to apply for a fee waiver. Service of process. Now, once you file the petition, the other party must be served with the petition, which means they must receive formal notice of your request. This is usually done through a process server, but it can also be done by certified mail in some cases. The other party then has the opportunity to either agree to the modification or contest it. Mediation. In many Texas counties, the court requires mediation before proceeding to trial. Mediation is a process where a neutral third party helps both parents come to an agreement about the modification without going to court. It can be a very cost-effective way to resolve disputes. Trial. If mediation doesn't result in an agreement, the case will go to trial. At trial, both parties will present their evidence and testimony, and the judge will make a decision based on the best interests of the child and other relevant factors. Final order. Once the judge has made a decision, they will issue a final order that reflects the modified custody, support, or property division orders. This new order will take effect immediately, and both parties must comply with it. Now that wraps up my overview of modifying custody, support, and other orders after a divorce in Texas. It's a complex process, but understanding the legal standards and steps involved can make it easier to navigate. If you're considering a modification, remember that every case is unique and consulting with a lawyer is key to ensuring your rights are protected. Thanks for watching. Don't forget to like, share, and subscribe for more videos on family and divorce law. If you have any questions, please feel free to leave them in the comments below and I'll try my best to answer them. Thank you and good luck.